All right, hello everybody. This is Mark Young again, CEO of myHRcounsel. We're really proud today to co-present with our one of our newest partners, TopDogHR, the world-class leader in background checks and as well as we do have you on mute as a crowd, so if you do have any questions, you can click on the question or the chat buttons that should have come up on your GoToWebinar dashboard. Happy to do it. Along the way, we'll answer questions if they relate to the slides that we're on. If not, we'll stay on the line and answer questions at the end. I'm happy to have two of my esteemed colleagues here. First is Janelle Stanton, and she's a senior advisor, a senior lawyer here at myHRcounsel, and has been focused on small and medium-sized businesses. She's a great presenter and really knows her stuff on employment law. And one of our newer attorneys, but she has been practicing for years, is Britt Waterman. She's also going to present today. She is a judge, a former judge, so I like to say we expand our knowledge here at myHRcounsel in addition to attorneys. She has been an administrative law judge, so she knows what our attorneys, how to set up our attorneys and teach them well as to how judges look at the advice that we're giving, and when it gets to court and when it gets to adjudication, what's going to really matter. So it really is a helpful team member to us to really think about how do we ultimately protect our clients. Today we're going to talk about background checks and the many challenges in using them, the pitfalls, etc., and hopefully that'll drum up many questions. Let me just talk a little bit, just a brief overview of our TopDog and myHRcounsel partnership. So together we get to provide the world-class hiring, onboarding, and screening tools and advice. So I know there's a lot of you out there that use background checks, hopefully use TopDogHR, but a lot of times both in the process and in the results, what do you do with it? Do you call back to the background checking company and ask them, hey, somebody failed this, or I need to maybe add a form, or how do I make sure that I'm not violating state and federal laws as to how I apply these reviews of employees? We do provide transparent and a flat fee pricing both on the background check but also on the unlimited employment law advice. So I think where we marry up well is we really are focused on efficiency and effectiveness with the client. If you think about other companies that do this, what a great business model lawyers and other advisors to hiring have when they get to charge by the hour or they get to charge by the problem. Why would they be incented in any way to make sure that they're both proactive and efficient in the way that they get things done? What we love about TopDogHR and Lauren and James is that they too have the same sort of philosophy and spirit as to going to market, arm in arm with their clients. And to prove it, you have to have a business model that backs that up, and we think we have that. And for those of you that are clients of either one of us, hopefully you'd agree that we have strong customer service focus. Certainly that's what we strive for, and it's a very important piece to our business. So with that, let me click over and let you hear a little bit about TopDogHR, and then we'll get back on the background legal stuff.
Thank you, Mark. Thanks for the introduction. Thanks for being on, everyone, today. I appreciate your time. This is James Marks with Background Info USA, and I also have Lauren Meehan here, the CEO of TopDogHR. Say hello, Lauren.
Hi, everybody. Thanks for joining us today.
And for those of you who don't know who we are, a little bit about the history of TopDogHR and Background Info USA. We started out in 2005 as a Florida corporation, and we're incorporated under the corporate umbrella name of Background Information Incorporated. Under that corporate umbrella, we have two divisions: Background Info USA, that handles the background screening division, and then in 2015 we started a new division known as TopDogHR. And the reason why we did that is because over the course of the years, our customers were constantly coming over to us and saying, listen, can you develop some software that can facilitate our talent acquisition, hiring, manage our hiring and onboarding, and so we don't have to go out to a different company. So what we did is we went to the drawing board and we started creating some software, and we came up with TopDogHR, and we introduced that to the market in 2015. The reason why we have the Boston Terrier logo there is that Lauren is very involved with the Boston Terrier Rescue of Florida, and the actual logo was shot from the face of a Boston Terrier that she rescued in a Florida hurricane 10 years ago. So, and she still has that dog today. So that's how we came up with the logo and the name. Somehow, Lauren wanted to incorporate the name and the logo into the new business launch. Next slide. Mark, next slide. There you go. Thank you. Okay, so what TopDogHR offers is we're a complete talent acquisition software. And what does that mean? We can post to any job boards that are out there. We can attract any talent from those job boards and onboard the new hire or the applicant into a software platform that's all inclusive of managing the applicant, conducting the background check, and bringing them into hiring the new employee, sending them hiring documentation. So it manages everything on one platform. With our partnership with myHRcounsel, we're also able to provide you with any kind of legal assistance that you would need, and that's facilitated through our partnership with myHRcounsel. With the background check piece, we want to point out, and this is what we're going to talk about today, is we only conduct background checks that are 100% FCRA compliant. And I think as we talk further in today, you'll understand what that means. If some of you don't understand what the FCRA stands for, it's the Fair Credit Reporting Act. Some companies refer to it as the Fair Consumer Reporting Act. It could mean it's basically the same thing. Compliance is our number one concern. All of our background checks are conducted for pre-employment purposes and or your current employment purposes. What ends up happening is a lot of companies, what they do is they'll hire somebody, and then 6 months later they'll do another background check on that employee, because from the time that you hire someone, if they commit a crime, you're never going to know it unless you recheck and do a background check again. So, and lastly, all of our background checks are 100% consent driven. What does that mean? You need consent from the applicant before we will run a background check on them, and this relieves you from any liability. So, and I know Mark's going to talk more about that today.
Next slide.
Very good. All right. Well, thanks, James, and thanks, Lauren. Just a little bit about myHRcounsel for those of you that don't know us. And I think what really puts the two of us together in a really good place is we all know, hopefully you're doing background checks, pre-employment and during employment. But what we find with clients so often is the paperwork for consent, et cetera, isn't in place, and likely isn't in policies and in manuals, and that's where people get themselves into trouble. And we'll talk a little bit about some of these big class action suits, several that are going on right now. But they're easy fixes, or they should be easy fixes. And what I found as being an in-house lawyer for many years, being the CFO for many years, we did a lot of background checks on all of our employees. And unfortunately, I can probably say that we didn't have the correct documentation and probably didn't update our handbook and policies, as often as we should. And the main reason is there wasn't a great service out there to do it. There's services out there that do HR monitoring. So HR AnswerLink, Think HR, some of You may even have those services. You know, they're advisors. They are websites that will give you some templates and might give you some articles, but ask them to, you know, provide legal advice or legal documents, and they're not allowed to do that. And then we all know, you know, we can all rip on ourselves, at least Janelle, Britt, and I, about the business model of lawyers. You know, you're paid on how many hours you bill during the year, and you know, that incentive to bill more hours doesn't align with getting things done faster and being proactive in sending out the policies and stuff that are compliant with various state and federal laws, because then you don't get paid as much and you don't hit your numbers and you probably don't stay employed. So we're different in the way that we set this up to be unlimited. You have unlimited access online and by phone to employment lawyers. So we have 50+ employees that are experts on employment law, and we do everything from, you know, again, review your background check policies and documents, employee manuals, HR audits, all the way through termination agreements and separation agreements. All 50 states, all federal law, and frankly global. We have offices outside of the U.S., and so we're focused on what everyone's struggling with, which is keeping up with all the state, city, county, federal laws, and then doing something about it. And what we like about it is we do have a consistent pricing model. So the PEPM, the per employee per month, very similar to how you pay for software, again, aligns nicely with clients in that we don't get anything for driving the number of hours up. And so, again, we're responsible for being efficient and being efficient with your use of time versus the other way around. So with that, let me turn it over to Janelle and get to the heart of the matter.
Awesome. Thanks, Mark. Yeah, so we're going to talk first about the importance of compliance with background checks. So background check policies and procedures are governed by federal, state, and municipal law. There's not, unfortunately, it doesn't make it very easy to just look at one. You have to consider state and municipal law overlays as well. The employers that are out there that engage consumer reporting agencies to perform these background checks, this is, you know, kind of the bulk of what we're going to talk about, because when you engage a consumer reporting agency, that's when you have to abide by the Fair Credit Reporting Act. And while employers are often held to a lot of standards with that, the CRAs are also subject to federal, state, and municipal laws. So there's a myriad of laws here that you can kind of get tangled up in. But, you know, along with that sort of compliance headache, there's serious advantages to conducting background checks. And one of the biggest is to reduce the risk of liability. Background checks can help. You know, there's claims out there called negligent hiring, for example. If you were to, you know, not run a background check and hire a person with like a dangerous criminal past, and either they injured an employee or injured maybe a customer, the employer could potentially be on the hook for a negligent hiring claim. So an important area where you can reduce liability. You also reduce the risk of employee theft and dishonesty. You know, when you're requesting this type of consumer credit information, if you have an employee who you know will be handling large amounts of money, will maybe owe fiduciary duties to your own clients and customers, if they have those duties placed on them, the reducing that risk by being sure there's no theft or other crime, dishonesty-related crimes on their record. And also compliance with immigration law. This is a really hot button issue right now, and these background check policies can help you stay in compliance with that as well. So background checks, employers can use background checks to get a lot of different information, credit information, you know, related to somebody's credit worthiness, criminal records, obviously speaks for itself, medical records in some situations, educational records, you know, if there was, again, thinking about dishonesty, if there was maybe at an educational institute plagiarism or some type of other dishonesty at the educational level, previous employment records, military records, which again, you do also have to be very careful with the use of them, but that is a type of information you can find out about. Prior bankruptcies, civil court records, and driving records. You know, if you're hiring somebody for maybe a DOT position or a driving position, you want to make sure that, you know, they don't have a litany of, you know, suspended licenses, and that they have a valid license, they have a valid CDL. Again, those are all the types of, you know, different types of records that employers can get with the background check. So like I said before, federal, state, and municipal laws may restrict and often do restrict the gathering or use of those types of records. This is just a small sampling. Every state is different, basically, and one way to think about this, so we have the federal law under the FCRA, but if you have a state that imposes more employee-friendly laws, those states' laws are going to trump that federal law on that issue. So, for example here, Illinois, Nevada, and New York City prohibit using credit information to make employment decisions. So you cannot seek out information about an applicant's creditworthiness in those states. That would be a violation of their law. So while allowed under the FCRA, not allowed in those states. As I kind of hinted at on the last slide, you know, requesting medical records can raise ADA and the Genetic Information Non-Discrimination Act. So if you request medical records that turn up, you know, records of somebody having a disability, for example, and then you don't go forward with hiring that person, you could be inadvertently walking into an ADA claim. The genetic information, you know, you can't discriminate against somebody based on their genetic information. So if you ran a medical check and you came across, you know, I don't know, somebody has a higher predisposition for Alzheimer's, and you didn't hire them on that basis, that would be potentially a GINA discrimination case. You also cannot take adverse employment action based solely on filing for bankruptcy. You know, there's really specific laws here. Bankruptcy is a legal remedy that people are allowed to take. It's meant to get them out of a bad financial situation. So you can't just point blank say, well, you filed for bankruptcy, that must mean you're dishonest. You can't just take an action based solely on that filing of a bankruptcy. You know, it's always a good idea to check with counsel to find out what you can actually request and how you can use it. Because, like I said, these laws vary, and every state is so specific with, you can't consider crimes that are this old, or, you know, crimes that did not result in an ultimate conviction. The laws are really, really specific. And I'm going to talk a little bit about the importance of compliance. So that Fair Credit Reporting Act, it applies to background checks that are conducted by a third-party service provider, CRA. So employers that use a CRA have to comply with the FCRA, and that has imposes requirements regarding disclosure. So letting the employee know, you know, what you're doing, that you're going to be running these background checks, letting them know their rights. There's consent forms, in addition to just handing out information about, you know, that you're going to be running it. They have to also consent to the background check, which is, you know, one of the things that TopDogHR prioritizes is getting background check consent, which is awesome. You know, certification, and then those pre-adverse, adverse actions. So a litany of steps that you have to take if you run a background check. You get a ding, you get a hit on a criminal history, for example, you know, the steps that you have to follow to be able to then take an adverse action against that individual. So on the disclosure side, which I was just talking about, so before you do a background check with a CRA, you have to inform the individual that you're going to be requesting a report. That disclosure has to be easy to read. Us lawyers, we like our legalese, but this is not the place for legalese. You need to be able to have anybody look at, read, and understand your consent form. That disclosure form has to be separate from other documents. You cannot bury the disclosure form in an employee handbook. This has to be something that's a standalone, something signed separately. You have to include a summary of rights under the FCRA. So again, this is talking about all the rights that they would have that are governed by that law, and that's actually something that summary of rights you can actually find on the Consumer Finance Protection Bureau. We put the website in there as well, but super important. That's a separate document also that every applicant and employee should be getting. We'll talk a little bit about consent. So the consent, again, that has to be in writing. You can't, you can't get a verbal yes on this. You need this and want it to be in writing to show if there ever is any allegations of violation that you did receive the consent in writing. It's got to be separate and applicable only to the background check. So, this document you can't have, again, buried in an acknowledgement within your employment handbook. That's not going to be enough. You have to have this separate. And you cannot check an I agree box. So you've all seen them, you go on a website, you're going to buy, some spiffy new shoes. You got to agree to their terms and conditions. You check the box and you move on. That doesn't, again, that's not enough for here. You need this really to just be in writing, separately, something that's signed, and that's what you'll need to do so that you can comply with the consent requirements. As far as the certification, an employer who uses a CRA for a background check has to certify to that CRA that they're going to comply with the disclosure requirements, that they're going to comply with the adverse action requirements. So again, those are before you decide not to hire or you terminate those adverse action requirements. And also that the employer is not going to use that information to violate equal employment opportunity requirements, isn't seeking out that information to exclude somebody based on their race, gender, those types of protected classes. That certification form that's provided by the CRA cannot impose additional obligations. So, something that I've seen actually a few times now in background check forms is a waiver of liability, saying that, if the employer violates the law, the applicant or employee agrees not to sue the employer for that violation. In some states, that's not allowed. And I've seen that in some forms, and, so you have to be really careful with any additional obligations that might be included in those. And again, you'd want to check with counsel to make sure the certification form complies with the statute in the state where you're going to be running your background checks. So another area I've kind of talked about a little bit, this pre-adverse action. So, you contacted your CRA, you've had them run the background check on an applicant, and you see, there was maybe they committed a theft 2 years ago, and you're going to hire them as a cashier. So you're thinking, I don't want to hire this person. Well, before you make an adverse action, which would be not hiring somebody, firing somebody, not promoting them, any employment action that would basically be negative to the employee or applicant, before you're able to do that, you have to provide that individual with a copy of the results of the report. So in some states, they have a right to get that anyway, but just in general under the FCRA, they have the right to get a copy if there is a hit on their background check. They have to be given a written summary of their consumer rights, so similar to this summary of rights under the FCRA, and they need to be given at least 5 business days to respond to the results of the report. So, you can't just give them the report and say, see ya. You have to give them an option to actually respond to those results and, potentially give an explanation. If it's something that is, a bankruptcy, they got divorced and, it was a hardship, they'd stopped paying, and maybe you end up with somebody who it looks like a horrible situation, but you actually, once you hear it in context, you're like, this person actually is trustworthy. You have to take that all into consideration. So let's say you go through all that pre-adverse action, and they have the chance to respond. You think, you know what? No, this is something that's going to disqualify them. So after taking that action, you also have to provide notice to that individual that explains the adverse action that's taken. You have to give the contact information of the CRA that you use, and a declaration that the CRA cannot provide specific information about the underlying reasons for the adverse action, and that it did not make the adverse action decision itself, that was on the employer to make that decision. A notice of the individual's right within 60 days to request and acquire another copy of that report at no charge, and then notice of the individual's right to contest the contents of the consumer report. This is really huge because, I can't tell you, I used to do sort of general practice, and we would have clients call in and they would say, hey, I'm trying to buy a car. All of a sudden I realize I have bad credit, and all these things are on there. I didn't try to buy a car in California. I live in Missouri. There can be inaccuracies on these consumer reports. They're not ironclad, and it could be possible that the applicant or employee goes through a process of disputing this on their record, and it gets taken off, and it's not something you could consider against them. So again, these pre-adverse action, and what you need to do to comply with that, they're very important steps to take and shouldn't be missed. So I'm going to hand it over to my colleague Britt, and she's going to talk to you about the scary stuff, the penalties.
Right. So employers who violate the Fair Credit Reporting Act, it can be a lot worse than it sounds. So a violation, you may be required to pay damages, punitive damages, attorney's fees, and court costs for the whole proceeding. And the damages are capped at $1,000 per violation, but a report of one violation often leads to the discovery of multiple violations, which can add up. So it's not something that you can. It's not cost effective to say, you know what, we're going to do it our way, and if this pops up once in a while, we'll pay the $1,000, no big deal. That's not an advisable path to take. The individual that's bringing the suit or the violation, there has to be a showing of actual harm to that person. But there are a growing number, we'll talk about in a minute here, a growing number of class action suits where you have potential applicants or employees who are alleging violations who get together in one suit, and these are million-dollar judgments. And like I said, you may think, hey, this isn't going to come up. What are the odds that somebody's going to come forward with this? Once you have one applicant or employee who seeks out an attorney, it is very easy for them to start locating other people who may also have a claim. So, I mean, with social media, all it takes is one attorney to put it out there on social media. Hey, have you ever applied at this company and been turned down? Can really get the ball rolling and end up in, like I said, millions of dollars in judgments. So another risk is performing a background check internally. So background checks that are performed internally, which is a Google search or a social media search or a search of an online publicly available database that an employer performs without using a credit reporting agency, is not subject to the FCRA, but these internal background checks can be extremely risky. The first risk is making a search that's going to reveal protected class information or evidence of activity protected under the NLRA. So you may try a Google search of your applicant and find out that person's race or that person's age, which would be protected classes, they would be protected from discrimination, and it could lead to a claim of that person saying, well, you know, they extended this conditional offer, they seemed on board until they Googled me and found out I was over 40, and you know, now it's a discrimination case, or finding out that the employee has been involved in union organizing in the past. That's protected activity, and that can lead to a claim if somebody makes a claim that you did not hire them because you found out about previous union activity. So taking that adverse action after you've inadvertently stumbled on some protected class or protective activity, then that opens you up to a discrimination claim, which is just as serious. And another point is, like we've been talking about, federal, state, municipal laws all very widely have different protections. An example of a problem that could come up with an internal background check. In California, you can't consider a criminal conviction if it's been expunged or if that individual has entered a diversionary program. You can't even consider that. Well, if you're doing a search of public databases on the internet, you could find an expunged conviction or a conviction that led to a diversion. And if you're using that in your making your employment decision, you're violating the law and you're liable for the violation in that point. So I just can't stress enough that going rogue, going without using a CRA is not advisable. So many states and municipalities, cities, counties, the trend is really to enact laws that are regulating the collection and use of criminal background information. And the purpose of these laws that are being passed is to help people who have criminal records re-enter the workforce. And that's an estimated 70 million Americans that have some sort of criminal history. And allowing these people to re-enter the workforce has been shown to reduce crime and poverty and unequal treatment. The failure to hire people or sort of hiring ban against people with criminal records leads to unequal treatment based on race and ethnicity. So that's what these laws are trying to combat. So there's one type of law you may have heard this phrase, ban the box. So ban the box laws remove questions about criminal history from employment applications and delay the timing of these inquiries about criminal history until later on in the hiring process. So a ban the box state or city would prevent you from weeding people out before they get a chance to even consider the application. And 29 states and over 150 cities and counties have adopted some form of ban-the-box law or ordinance, meaning over 2/3 of Americans live in a jurisdiction with some type of ban-the-box or fair chance law or ordinance, which means if you're a multi-state employer, the odds are extremely high that you're hiring people who live in a jurisdiction or work in a jurisdiction that's got some form of these ban-the-box or fair chance laws. The ban-the-box is removing the criminal history question from the employment application and delaying that. Often it's until a conditional offer of employment or an interview has been extended. Fair chance laws are a little different. Fair chance laws also will prohibit the inquiries about criminal history and the criminal background checks until after a conditional offer of employment has been made, after you've determined that this person is qualified to be hired for the position. The fair chance laws often involve an individualized assessment, which is taking the criminal history information that you receive and performing an actual, sitting down and performing an assessment to determine, okay, well, we found about this conviction. How is that going to relate to the actual job that this person is going to be performing? Is there a connection between this, or are these two totally unrelated subjects? And these laws often require employers to make a good faith background as to which positions require background checks. So this is when you're writing your job descriptions, you want to take a look at those job descriptions and determine whether or not you even need to make a criminal history check. So the ban the box and the fair chance laws, as I touched on, kind of vary on several factors. The point in the hiring process at which a background check can be performed, and that's going to vary state by state, city by city. That the point in the hiring process at which you can start the background check is something that you want to check with counsel to make sure you're following the rules in your particular location. The ban the box and the fair chance laws vary on what type of determination has to be given to the applicant before and after the check. How long do they have to respond to the results of the background check, and what is the nature of the relationship between the criminal history and the job for which they're applying? What is the nature of the relationship that has to occur before that adverse action can be taken? And even states that don't have a ban the box or fair chance law, you still need to be careful when you're requesting types of information and using the types of information in making a hiring decision. For example, Wisconsin does not have a ban the box law, but they do prohibit employers from asking about arrests that did not lead to convictions. So you can ask about criminal history in Wisconsin. You can ask, have you ever been arrested? If you ask that question, you're violating the law. That's a violation of Wisconsin law. California does not allow employers to seek or use information about non-felony marijuana possession convictions that are 2 or more years old. If that comes up on a background check, you can't use that. You can't even consider that in making your decision. And I think in talking about the fair chance laws, I think the purpose of these laws is, to, like I said, to consider the nature of the position and how that relates to this person's criminal history. You may have someone who has a DWI conviction on their record, and I think, I'm not sure about other jurisdictions, I think in Minnesota it's 1 in 7 individuals have a DWI conviction. So this is a lot of people we're talking about and potentially excluding from the workforce. And I think the fair chance laws are saying, hey, let's rather than saying if you have a criminal conviction, you can't work for us, let's take a look at what it is that happened and what it is that we're asking you to do. If you've got someone who's, you're hiring to drive a school bus, that DWI conviction, that may make sense for you to consider that. If you're hiring someone to be an accountant, and that applicant has a DWI conviction, you could be missing out on a really great applicant if you're just having a sort of blanket ban on criminal history. So the fair chance law, I think, they benefit applicants in helping people re-enter the workforce, and they benefit you as an employer for allowing you to take a closer look at people who may have been screened out and may end up being really great employees.
So ladies, there is like so much stuff here, and other than myHRcounsel, there's no way you could sift through all this, right?
Oh, no. This is so complicated. All the different states, municipalities, counties.
Yeah, so the good thing is, for those of you that I see a lot of clients on the line, if you go on the portal, 1, you can ask the question on any of these, and 2, we have all the laws and the notices, the consent forms, et cetera, that are on there that you can pull off. But I set that up a little bit because, so what? It seems like a lot of work to do. What possibly could be, a lawsuit, but maybe you can settle that and it's one individual, right? How big can that really be?
Well, let's talk about that.
Well, then let's do that.
So you can see some of some very well-known companies have run into this. Uber just paid out a $7.5 million settlement for wrongfully applying the FCRA's general employment provision and also wrongful firings as a result of misusing these consumer background checks. McDonald's paid out $950,000 for running credit checks without making the disclosure, like we talked about, that form that needs to be a separate form and can't just be checking an I agree box in the middle of an application. McDonald's didn't make that disclosure properly, and they ended up paying for it. Lowe's paid out a $2.2 million settlement to compensate a class of prospective employees for failing to provide a copy of the report. And again, it seems like not a big deal. Hey, we're just going to tell them that we don't want to hire them and send them on their way. This is what happens when you don't provide copies of the report as is required by law. And Dish paid out a $1.75 million settlement for failing to give that legally compliant disclosure like we talked about, and also for barring technicians that they considered high risk from working on projects without giving that pre-adverse action notice, without giving that notice that says, hey, this came up, and this is what we found on you, and giving them a chance to respond to that. Dish didn't do that before they pulled these people off the projects, and they paid for it. When we set up this presentation and set up these slides, and then just this morning before we came in here, I got in my inbox one of the legal blogs that I subscribe to. Someone just filed a class action in Georgia against Starbucks on September 20th. So this is a plaintiff and found a number of other people. They're proposing a class action for Starbucks refusing to hire people without giving them copies of the reports and giving them the notices of right, so that those separate documents that we talked about that have to be given out before you can perform the background check. So that just popped up a week ago.
That's great. So if I add these all up, that's, at least they would have had 2 or 3 months of myHRcounsel services. So it's amazing. But I'll be honest with you, back in the day, running a large HR department, I didn't know of the detail of when criminal convictions came up, and especially with felony convictions, the process. And I had someone that I found who had changed their name, et cetera, but had a murder 2 conviction, and we had client contracts that said a level of felony that could not be people that would go on site, and that was the person's job. And thank God I did a little bit of research and found out, the pre-adverse action and the notice, and then the 5 days to get back and have that discussion, or that would have been an expensive lawsuit.
Think about the negligent hiring claim there.
Yep. So maybe just in summary, again, we kind of hit on the things. You can hammer this home: check with counsel, check with counsel, check with counsel. Use the kind of counsel. I mean, honestly, if you're not using us, that's fine. We think you should, but make sure that you're taking a check and going through this at least once, because there's so many moving parts that, again, most of us are not aware of. And we do background checks. TopDog does a great job of making sure that there's the right documents, and going through the electronic, makes the fact of hiring and going through and getting these disclosures a little bit more consistent. But don't take it for granted. We probably see 50% of our clients come in with applications that still ask, have you committed a felony? It's just amazing how many times we see that. And then we get, a ton of questions on, hey, we went through this background check, drug testing, obviously a big issue around marijuana, et cetera. It shows up in blood for, how long? 3 weeks, 4 weeks? And what kind of policies can you have on that? What kind of policies can you have in your employee handbook about hiring or committing a certain level of crime. It used to be you could just say, we're not going to hire anybody, that has done this, and that isn't the case anymore. If you haven't done so, updating job descriptions to make sure, again, as Britt talked about, what you find in a background check, if it has no bearing on the person's job duties, et cetera, you're setting yourself up, it might be convenient thinking, I haven't, hired somebody with a misdemeanor in this area, whatever, but you're setting yourself up for, not only an individual suit, but potential class action suit if it has no relation to the job. Above all, and we always talk about this, do these things across the board and do them consistently. If you do get yourself into trouble and, for whatever reason you have not trained managers to ask the right questions, or you put some people through background checks and others not because they're in different offices or whatever it happens to be, the inconsistency is where plaintiff class action attorneys, like the ones that went after the Lowe's and the Starbucks, there's a group of them that are looking for those type of things and advertise for it, et cetera. But the more you can be consistent, and again, the more you can lean on counsel to make sure that you have a check-in, especially if you're not sure on which way to go with a background check where you get some information. Make sure that you get that and make sure you have it documented, and that'll at least protect you from the standpoint of you could make a bad decision, but it wasn't in bad faith, et cetera, and that'll minimize your damages.
And Mark, I'd like to just add in that we see many companies that will run the background checks. It'll come back that the applicant or the current employee has a clean background check, and then they have these amateur employees in their company that are Googling, and they're like, oh, this person was convicted of a crime. Why he shouldn't be working here, or she shouldn't be working here. And it turns out that it's something that was beyond the 7-year period, or there's some other mitigating factor. So we see that all the time, and it's always a big concern.
Yeah, that's a great ad. I mean, the reverse of what my example was is there were 3 people that referred this person in and said he was great and everything else. Turned out the 25 years that he worked was all at penitentiaries. They just happened to, so-and-so incorporated, so-and-so LLC, and so he made it all up. But he had been out of jail for 2 years and met some friends and everything else. So again, we almost skipped over the process, and I'm sure there were multiple internal people that thought I was wasting money and were upset because everyone consistently went through a background check. But again, when you're doing it internally, or you're, the rumor mill or the word of mouth, a lot of trouble can happen when those things get tripped up. So I don't see any questions so far. If you do have any questions, again, click on the question button and send that in. We'll wait on here for maybe 30 seconds, but if questions don't come in, on behalf of Lauren and James and Janelle and Britt, we really appreciate you taking the time. We will follow up by sending out an email with the details if you are looking for the HRCI and SHRM credit. This does qualify you for one. We have submitted that and gotten the code back that you need. Also, we'll send out, you can see a handout that's attached here, but we'll send out, we've recorded this, and we'll send out a link to the recording if you want to, play it multiple times, hear Janelle and Britt's voice for whatever reason.
You guys not have a good time.
Yeah, or frankly, if you want to, if you have other people in your HR department or hiring managers, feel free to use this in a team day or just in a training. Because we do think it's really important just to, if nothing else, a red flag pops up and you ask some questions as we go through, again, the process of the front end, the paperwork, the qualifications, hopefully you're using background checks and then how you use them, as well as making sure your policies and procedures are up to date and consistent. So I do have, let's see, it looks like a couple of questions. How often can background checks be run in California? So that's a good question. I don't think that there is that we know of. I don't think that there is a qualification on how often. I think the warnings there is make sure that that's documented, that you're going to do these things, and make sure you're consistent. So don't, worst thing you could do is pick on a protected class, or, unbeknownst to you, the numbers show up that a protected class was given, 50% of the background checks, and perhaps you weren't doing it consistently across the board. Drug testing, there's a bunch of rules around. That's a whole nother hour or two of legal issues. But to the extent that you're drug testing or random drug testing, make sure that you seek counsel on that. Yeah. Make sure you have policies in place and the right disclosures and consent forms.
Yeah, and the consent form should also be giving consent for for the check to be run pre-employment, but then throughout the employment relationship, you can put that in the actual consent form. That should be there to give you that authority to run them.
And if you have employees in California, if you have employees in Los Angeles has a fair chance, San Francisco as well have fair chance laws that are extremely detailed. So if you're running background checks on employees in Los Angeles or San Francisco, that's something where you definitely want to check with counsel to know the intricacies of the law, because in those municipalities particularly, you've got a lot more requirements than just handing out the disclosure and getting the consent form signed.
Sure. So a couple more questions. What's the best source to read about ban the box rules? So Claudia, we have a whole series of, if you click in the portal and type in the search ban the box, I think we have a couple articles on it, and states and cities that allow that disallow that ban the box. Disallow asking about that on an application. Yeah. So you'll get all your information there, and you can find out. I know you're in a lot of cities and states, and to the extent you have any questions on it, shoot us a ticket, and we're happy to look at it specifically. Lauren James, this one's a good one for you. So question is, we're working for a nonprofit organization that can't afford high-cost background checks. What's your best recommendation?
Well, I think first we have to understand, are they volunteers or are they employees? What are they going to be doing in the organization, what their position is and job description is? Are they interns? And then we determine, based on budget, what is the best course of action to take to get the most comprehensive background check done to stay within your budget. We make recommendations as to how comprehensive you want to be, and then you filter that through within your board and determine what the best course of action to take. So there's not one definitive answer there. It's a process that we can go through and get those questions answered to come up with the best course of action to take.
And we do have a lot of nonprofits that we do background checks for, but as James mentioned, each one is going to be tailored to the organization based upon whether they're dealing with small children or if they're working at a veterinary care facility. Any other questions, Mark?
Yeah, I got just one more. So the question is, we have, in essence, we have a private investigation company, and our employees have access to highly sensitive information. I worry about doing background checks, and having our employees thinking we're discriminating over history. Again, perfect example of why background checks are needed, one from the standpoint of information and the type of work that they're doing, You know, from the standpoint of, you know, protecting yourself from discrimination, et cetera. Again, it goes back to making sure that you have a written policy that, you know, follows the law. You know, you have a disclosure on the front end that's separate from your employee handbook, et cetera. And then you're consistent. You know, so if you're running a consistent program with all new hires, and maybe you're doing updates every 6 or 12 months because of the sensitivity of the information that they have their hands on, you should be okay. If there has been cases where, you know, your employees have brought that up, reach out to us. I'd be interested in just what the variations of that are, you know, in terms of, you know, are an employee or two complaining about it? Again, do they feel like they're the ones being singled out or something like that? But consistency in written policy kind of always saves the day, at least with lawyers. So.
And I'd like to just put in one more pitch for job descriptions. Have job descriptions, because if you can show that creditworthiness or something like that is a bona fide occupational qualification, this is something that, this is the job description, this is the type of information this person is handling, this is, you know, this is why we need a history of creditworthiness or a history of, you know, no crimes of dishonesty. If you've got that right in the job description, and everybody who's applying is applying for the same job, you've got the description right there, and you can show that it's necessary for that position, that's going to help you out as well. So you should have those done before you start screening applicants.
Perfect. All right, so we're right on 2 o'clock. Thank you, everyone, for attending. Lauren, James, thank you very much. I'm glad to hear that things are improving day to day in Florida, and we're always thinking about you. So thanks, everyone. Have a great rest of the day.
Thank you, Mark. Thanks, everyone.